Hello and welcome to this session in which we will keep working with the elements of the contract. To have a valid, enforceable, legal contract, the contract will have to have three elements, which are an offer and an acceptance, an offer made by the offeror and an acceptance made by the offeree. Simply put, there's a mutual assent, a mutual agreement between the two parties. There's an exchange of value, which is an exchange of consideration between the two parties. And there is no defense to the contract. In other words, the contract is enforceable. There is no reason for the court not to enforce it. And we'll talk about no defense in a separate recording. In this session, we will focus on the offer and the acceptance. In what sense? Because to establish a contract, the contract has to be accepted before it's withdrawn or terminated. So how about if the contract is terminated and how the contract can be terminated? This is what we will focus on in this session. Before we proceed any further, I have a public announcement about my company, farhatlectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses, broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
So let's talk about the contract termination. Well, action by either party can terminate the contract. Well, the person that's making the offer, the offeror, can do what? Can decides to withdraw. I'm no longer interested in making this offer. They can do this at any point before the offer is accepted. Guess what? The other person that's receiving the offer, the offeree, or the person receiving the offer can also terminate by saying, I'm not interested in this offer. Or it can be terminated by operation of law. Simply put, this refers to automatically terminating due to legal reasons like death of either the offeror or the offeree, due to the illegality of the offer, and few other exceptions. We'll look at those later on in this session. So in this session, we'll focus on each one separately. Revocation, or by the offeror, basically the person making the offer can basically say, I'm no longer interested in making this offer. Can be made directly or indirectly. So the offer can be withdrawn by the person who made it before it's accepted by the recipient. This withdrawal, known as revocation, that's the technical word, and it can happen either directly, direct revocation, or indirect revocation. Let's take a look at what does that mean, direct and indirect. Indirect revocation, when the offeror explicitly informed the offeree that the offer is withdrawn. Again, we're assumed before acceptance. For example, the offeror might call or email the offeree to say, well, they no longer wish to uphold the offer. Or it can be then indirectly. Indirectly is a little bit mean, kind of. This happens when the offeree learns from a reliable source that the offeror has taken action inconsistent with the offer. For example, the person making the offer already sold this item to someone else, indicating that they no longer intend to keep it open. Okay, if the offeror sells the item to someone else and the offeree finds out, well, it's considered an indirect revocation. It's not nice, but it's legal. Well, Lisa sent an email to John offering to sell her vintage car for $20,000. That's an offer. In her email, guess what? Lisa mentioned that John had 5 days to think about the offer. And during this period, she would not revoke the offer. Well, what do you think? Can Lisa revoke the offer within the next 5 days? And the answer is yes. She can sell it without even telling John. The very next day, Lisa received an offer from someone else willing to pay $25,000 for the same car. Well, guess what? She sold it. Excited by this offer, Lisa immediately called John to inform him that she has withdrawn her previous offer. Hold on a second. Didn't you tell me Lisa gave John 5 days? Well, she doesn't have to. This action by Lisa constitutes an effective revocation of her offer to John. Lisa did not even have to call John. Maybe John later on will find out that the car is sold. Okay? Exception to the rule. How can John protect this offer? Okay? Get an option There's an important exception to the rule that offers can be revoked: the existence of an option contract. In an option contract, the offeror agrees to keep the offer open for a specified period in exchange for some form of payment or consideration from the offeree. If John sends Emily, after he receives the email, a check or some money through Zelle, PayPal, somehow sends her some money, some consideration to keep the offer open for 5 days, then guess what? Lisa will have to comply. This type of agreement legally binds the offeror, Lisa, to keep the offer open for the agreed upon duration, making the offer irrevocable during that period. Now be careful on the CPA exam. Watch out for misleading answers claiming that the offer is irrevocable or an option. The key is, unless consideration was exchanged to keep the offer open, it's not legally binding. So remember, I told you, sends her money through Zelle, PayPal, a check, then we are good to go. So to summarize here, the offeror can withdraw the offer before it's accepted. The other way to terminate a contract is for the offer to be rejected by the person the offer being made to. Well, rejection by the offeree effectively ends an offer and prevents it later from acceptance. So you cannot reject and say, you know what, I changed my mind, I accept. Once you reject, it's done. And this can be done in two different ways. You can expressly reject it, express rejection, or you can make a counteroffer. In an express rejection, pretty straightforward. You refuse the offer. The offeree directly state, I don't accept the offer. For example, if someone offered to sell you a car for a certain price, you could say no, and the offer is terminated. If the offeree later decides they want to accept the offer, it's too late. Once you reject, that's it. What does that mean if you said, I want to buy it again? Now you're making the offer. Any subsequent acceptance is actually a new offer. Or it can be done through a counteroffer. What's a counteroffer? It's a little bit more complex than the express rejection. Here the offeree responds by proposing different terms. Now when you propose a different term, it's a rejection coupled with an offer. So the original offer is rejected and you are making a new offer. For example, if someone offered to sell you a car for $450 and the other party said, no, but I will give you $425. Well, this is a rejection coupled with an offer. Now you're offering to buy it for $425. The original offer is gone. That $450, that original offer is gone, and the roles are reversed. Now the original offerer is now the offeree, who can either accept or reject the new terms. Now bear in mind, mere inquiry or inquiries is not a counteroffer. So if the other party says, would you accept $425? This is not a counteroffer. How about I pay $425? Is not an offer. Is $425 acceptable? Those are inquiries, question marks. Those are not counteroffer. Mere inquiries are not. Let's assume Sam offers to sell his bicycle to Rita for $300. And Rita replies, no, I'm not interested. That's it. It's an express rejection. It's done. The offer is terminated. If Rita later decides she wants the bikes and tells Sam, I accept your offer, it's gone. Sam don't have to accept, because Rita is essentially making a new offer to Sam. Now, Rita offers to buy the bicycle for $300 and Sam's response, I cannot sell it for less than $350. Here what happened is Sam's reject the offer and made a counter offer. It means I'm not going to accept less than $350. This is how much I will accept. Rita can now accept or reject the counter offer of how much? At least $350. When is the rejection effective? When is the rejection effective? In contract law, a rejection of an offer becomes effective only when it's received by the offeror. So if I reject the offer, it's not rejected until the person made the offer received that rejection. It's going to be different than acceptance. We'll talk about acceptance separately. And this timing can have significant implication. How? Let's take a look at this example. On February 10th, Lisa emails Mark offering to sell her paintings for $500. 2 days later, Mark mails a letter to Lisa saying, I'm not interested, citing the price is too high. That's 2 days later. On February 13th, Mark learns that the painting is worth much more. And what did he do quickly? He quickly called and emailed Lisa, said, you know what, I accept the offer. So notice, he mailed the letter on February 12th. Now, Lisa did not receive the letter until the rejection letter until the 14th. Guess what? That letter that Mark sends, it's no longer valid. What's valid now is the acceptance, because the rejection is effective when it's received. On the 13th, Mark accepts. The accepts here basically makes the rejection that took place on the 12th null, because Lisa did not receive the rejection. Now, if Lisa received the rejection on the 12th and Mark emailed her, then yeah, there'll be a new offer, but that's not what happened. Okay, so in this case, even though Mark initially sends a rejection letter, Lisa had not received it by the time Mark called and accepted the offer. Therefore, Mark's acceptance is valid and a contract for the sale is formed. The rejection arriving later does not negate the contract. So, what else? How else can we terminate a contract? Termination by law. There is few issues we have to deal with here. So termination by operation of law occur in specific circumstances where an offer is automatically rendered void. It means it's no longer valid without any action by either parties. Remember, the offeror can revocate the offer. The offeree can reject. This is how we can terminate an offer or a contract, or the contract can be terminated by law. Well, under what circumstances? Death or incompetence. If either of the offeror or the offeree dies or become legally incompetent before the offer is accepted, the offer is terminated. This termination happens automatically without the need to inform the other party. Okay. Now, bear in mind that in case there is an option contract where the offeree has paid for the right to keep the offer open for a certain period of time. Do you guys remember we said, what should you do? Offer some money to keep the offer open and valid. Well, then the offer remains valid despite the death of either party. In such a scenario, the offer can be accepted on behalf of the deceased party's estate within the option period. So simply put, the person that passed away legally still exists through their estate and the option contract is valid. For example, D offers to sell a piece of land to Sue for $300,000. If either D or Sue dies before Sue accepts, it automatically ends. But if Sue has paid D an option to keep the offer open, then Sue or her estate could still accept the offer during the option period, forming a contract with D or D's estate that will keep it open. Another way a contract can be terminated is destruction of the subject matter. If the item or subject of the offer is destroyed before acceptance, the offer automatically ends. For example, if a car is offered for sale but it's totaled in an accident before the offer is accepted, the offer is nullified. Emma, for example, offers to lease her apartment to Jake for a year. Before Jake can respond, a fire destroys the apartment. Well, that's it, it's gone. The offer for the lease terminates automatically as the subject matter is no longer available. Jake cannot accept the offer since the apartment no longer exists in the original state. Also, termination can be due to illegality of the contract. This occurs when the offer becomes invalid because the subject matter of the offer becomes illegal before it's accepted. In those circumstances, the laws changes, rendering the offer void and it can no longer be accepted. Okay, for example, Lucky Lou offers Vegas a share of his casino business. Well, good. Before Vernon can accept the offer, a new law passed in that state banning casinos. Guess what? As a result of the new law, the offer from Lou to Vernon is automatically terminated, since operating a casino is now illegal. So the agreement to share in such a business cannot be legally upheld. Therefore, Vernon can no longer accept the offer because it's an illegal activity. Just to summarize, well, a contract can be terminated by revocation by the offeror, the person that made the offer, rejected by the offeree, or by law, operation of law. Those are the three reasons. Let's take a look at this MCQ from Farhat lectures. When can an offeror revoke an offer? When can they do it? Okay, because they can do it, but when can they do it? At any time, even after acceptance. Not at all. If it's accepted, it's too late. D is out. After the offeree has accepted the offer. Well, no. After the offeree has accepted, it's also late as well. So it's been A and B. Can they revoke at any time before acceptance? unless it's an option contract? And the answer is yes. They can revoke it anytime unless we have an option contract. Unless the option contract means the other party paid you some money to keep it open. A is correct. Only within the first 24 hours after making the offer, there's no such a thing. What should you do now? You want to go to Farhat Lectures, look at additional MCQs. That's going to help you prepare for the CPA exam, prepare for your business law classes, invest in yourself, invest in your career. Good luck, study hard, and of course, stay safe.